The
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Monday, February 7th, 2022, and this is a special episode of Short Circuit. Instead of talking about recent appeals from the Federal Courts of Appeals, we're going to be talking about the lay of the land in the state courts. So you hear a lot here on Short Circuit about barriers to having your rights vindicated when you go to federal court. There's qualified immunity and all kinds of other barriers that may stand in your way if the government does you harm and you're trying to seek redress. But what about going to state court if the state or local or even federal official violates your rights? Can you go to state court to try and vindicate that better than in the federal courts? Well, unfortunately, the answer usually is no. And we're going to talk about that news, but also hopes for reform that may make that news better in the future. We have a special guest joining us today to talk about a recent study that he and some colleagues had published in the Northwestern Law Review. His name is Alex Reinert. He's Max Froon Professor of Litigation and Advocacy and Director of the Center for Rights and Justice at Cardozo Law School. Alex, welcome to Short Circuit.
Thanks so much. It's great to be here.
But Alex isn't the only one joining us today. We also have two other experts in remedies law who I'm very proud to say are colleagues of mine at the Institute for Justice and will be no strangers to regular listeners. They are Anya Bidwell and Patrick Jaicomo, both attorneys at IJ. Welcome to both of you.
Hey, Anthony.
Hey, Anthony.
Well, so the two studies that are recently came out, first of all, is the one I mentioned that Alex had and some co-authors had issues who are also friends of IJ. And you've heard, if you've been listening to the series Bound by Oath, Joanna Schwartz and Jim Fander. And that's New Federalism and Civil Rights Enforcement. But also, just recently, here at IJ, we had issued a report, 50 Shades of Government Immunity, Complications with Bringing Civil Rights Claims Under State Laws. Patrick and Anya were instrumental in having that report issued. So we're going to talk today about the tableau, as you would imagine, under American federalism, of different states and how you can have your rights remedied in those states, but also the bad news, which you shouldn't have under American federalism, which is it's pretty bleak in just about, not all, but just about every state, and maybe the reasons for that, but also some solutions we have to this problem. So we're going to talk overall a bit about some of the often confusing levels of how you can go to court to vindicate your rights, both under federal and state court. Then we're going to move on to the nitty-gritty of what's on the ground in different states and talk about a few states as examples. And then we're going to conclude with some happier notes about what can be done in this area and what also has already been done to make things a bit better out there. So, Alex, maybe you could start us off by talking about the thing that most people are more familiar with, which is going to federal court to try to vindicate your rights there, and this thing we often throw around called Section 1983.
Sure, I'm happy to say a little bit about that. Section 1983 is a very old statute. It was passed as part of Reconstruction. It was part of the Civil Rights Act of 1871, although it lay in disuse for decades thereafter until the Supreme Court in Monroe versus Pape essentially made it a tool for vindicating civil rights starting in the mid-60s. It is a way for people whose rights have been violated by state or local officials to sue, usually for violations of the federal Constitution, sometimes for violations of federal law more broadly. Now, we should say that there also are circumstances in which people's constitutional rights are violated by federal officers. People who are in that situation can't use Section 1983. They have to use a doctrine called Bivens, which is much more limited than Section 1983. But the heart of both of these avenues for relief is that you have to show that the officer violated the Constitution. You have to show that the officer was personally involved. You have to overcome many barriers to relief, which I'm sure we're going to talk about in greater detail. So it's an avenue for obtaining relief, but it has many limitations.
And Anya, say for whatever reason, I'm a civil rights lawyer. I have a client who something bad has happened to them, say from a local officer or someone at the Board of Education or whoever it is, some state or local officer, and I want to go to state court. Why might that be a good idea? But what also might be the barriers to me going there? But maybe what would be the different causes of action I could have if I went there?
Sure. On the state level, you theoretically have three options available. The first option is really an analog to what Alex just talked about. Sort of Section 1983 type of a statute, but only, passed by state legislators. Basically, you have legislators, passing this statute that allows suits against state and local officials for violations of state and federal constitutional rights. Again, that's something that's absolutely up to state lawmakers to do. The second option, and again, we're talking in theory, right? What states can do. The second option is when the highest state court in each state recognizes an implied cause of action directly under their state constitution. It would be an analog to what Alex also discussed, the so-called Bivens cause of action under federal law, though you don't have the same reservations as you would in federal court. As our listeners know, federal courts are reluctant to recognize these because federal courts are courts of limited jurisdiction. On a state level, this argument is much weaker. So theoretically, why not just have state highest courts allow these rights of action without a need for the legislature to weigh in? Finally, the third option is really what the states generally do. It's having a personal injury statute, the so-called State Tort Claims Act. Every state already has them. A legislator essentially allows an individual to pursue a personal injury claim against a government worker. Sometimes there is an overlap between a civil rights claim and a personal injury claim, like in cases of excessive force violations. Sometimes there isn't, like in cases of racial discrimination. So this overlap is not perfect, but it can be an avenue for relief. And when we grade at IJ, when we grade states in our data set, we do give these states some points if they have decent Tort Claim Act statutes. And Anthony, to your last point, just having one of these options on the books really means nothing unless they are free of immunities. Section 1983 has been, to a large extent, weakened by qualified immunity, and every single one of these options that I discussed can also be, and often is, weakened in this fashion, where immunities prevent plaintiffs from being able to pursue their claims in state courts.
Right, and there's so many of those immunities, as if you've listened to our series Bound by Oath, you'll be familiar with. There's not just qualified immunity, but absolute immunity for prosecutors and legislators, and liability can be very hard to come across municipalities as well. So we'll get into more of that later also. Well, Patrick, some of our listeners probably are familiar with our advocacy at the federal level and trying to get either Congress or the Supreme Court to try to sort out some of these barriers, especially qualified immunity at the federal level. Well, why are we talking about the states now? Are we giving up with the feds?
Yeah, the short answer is no, we're not giving up. But as many of our listeners may know, the Supreme Court itself took up a number of qualified immunity cases a couple of years ago and gave everyone a little bit of hope that it might be reconsidering whether to get rid of the doctrine entirely, and then unceremoniously dumped them all in the summer of 2021 or 2020, I can't remember anymore, with only Justice Thomas dissenting from the denials of cert in those cases. And after that, a lot of people who kind of have a hand in the game of immunity and accountability threw their cards into the middle of the table and said, I give up on the Supreme Court entirely. The Institute for Justice, Anya and I, have very much been kind of running around telling people, don't give up yet. We can still make improvements here and there. And we've seen actually The court do things that make us think that it's willing to at least kind of adjust the edges of qualified immunity, but it doesn't seem likely that it's going to get rid of qualified immunity across the board. So that's kind of off the table as a realistic goal. And at the same time, Congress itself was considering federal legislative fixes, and everyone was excited about that. And then over the course of the last year or so, they kind of whittled them down, and then it turned into a situation where it almost became a poison pill that was going to go nowhere. And that's my daughter.
Hi, Cora. That's Patrick's baby. Basically, the Supreme Court, those petitions were rejected in the summer of 2020, right? And then summer of 2021 is when Congress gave up on JPA. And so we basically have these.
Right. So we're not giving up any optimism. We think that this is an issue of such importance. And given our federal system, we shouldn't just focus on a federal solution. We shouldn't just focus on a legislative solution. We should be focusing on state courts, federal courts, state legislatures, and Congress to ensure that because we have these rights from all those different sources. I mean, we have the federal Constitution, which after the Civil War and the 14th Amendment is supposed to set a floor for the way the states can operate as well as the way the federal government can operate vis-a-vis individual rights. We should have even more protection than would even exist if we only focused on the federal level. So this is both complementary and important as our federal system operates.
Now, a lot of critics of using Section 1983 in federal court and in federal civil rights law, and I'm including, say, Justice Gorsuch in this. I think he's probably the one most well known for this point of view I'm about to express. Is that, look, Section 1983 is important. Maybe not. Qualified immunity and other immunities are legitimate, but most of this should be done in the state courts. When you have, say, your local police officer does something wrong against a citizen, that citizen should bring suit, and it should be the first place they turn is to go to state court and bring a tort claim. And you'll see citations to William Blackstone and the common law of England, and that it used to be that you could just bring a suit against an officer, and you'd allege trespass or whatever the tort was, and as long as they didn't have an official reason that they could do that, they would be liable. So, what is wrong with just that point of view and having people go to state court to do that? What is the catch there? Why is Justice Gorsuch saying just go to state court, right? What is the problem with implementing that at the state level, Alex?
Well, sure, I'm happy to talk about that. I want to make sure that our listeners understand that there's a little bit of nuance here. We've talked a little about state court and federal court, but really what we're talking about is federal law and state law. That is, I can bring my federal claim in state court, and under certain circumstances, I can bring my state claim in federal court. There's overlapping jurisdiction for some of these cases. But to your question about Justice Gorsuch, I mean, Justice Gorsuch should know this. We have a statute, number one. We have a statute that is Section 1983. And Section 1983 was meant to enforce the Constitution. And so whatever rights we might have under state law, that doesn't mean we also don't have rights under this statute that is meant to enforce the Constitution. That's point one. Point two is the reason that we enacted that statute is because we didn't trust states to protect these new constitutional rights. And it was very important to have access to a federal remedy that one could bring in federal court if one so wished, because we were suspicious of whether states would be sufficiently open to enforcing these constitutional rights. That's point two. Point three, and I think this is extremely important, is that some state torts overlap with federal constitutional rights. Maybe the best example is a tort of battery. Overlaps quite closely with excessive force claims brought against officers. But some state torts don't overlap very well with constitutional rights at all. There are some rights that we have that really can't be enforced through state tort law. So those are all reasons that I would say it's not enough just to rely on state tort law to vindicate rights which we find in the Constitution and which should be protected.
And so given that there's that and you're absolutely right. There's kind of an overlap, but a bit of a mismatch too between some torts that you could bring, like negligence torts against police officers might not violate the Constitution, but you still should be able to bring them. Whereas a racial discrimination claim, it's not something that you could bring under the days of Blackstone, but it certainly should be able to bring it under the state or federal Constitution. When someone when we are looking to reform, making it easier to say bring a state tort claim for something wrong that an officer has made or a bureaucrat has made or what have you, or we're looking to bring a state constitutional claim. So the equivalent to Section 1983, but under the state constitution, where do you think legislators and reformers should focus their energies, and what seems to have the better bang for the buck if we're going to look at reforming the obstacles that are in both of those areas?
So if we're talking about reform at the state level, the state and local level, really, one thing to focus on first is to understand all the barriers that exist to Section 1983 liability and relatedly to Bivens liability. And some of these we talked about, right? Qualified immunity, I know your listeners are quite familiar with. Monell liability, which makes it very difficult to hold municipalities accountable when their employees violate the Constitution. Limitations from sovereign immunity, other forms of absolute immunity. Limitations on the kinds of attorney's fees you can get when you bring actions that aren't about damages, but that are actually forward-looking, attempting to reform systems, law enforcement systems. So that's, I think legislators should be focused on those failures at the federal level when they think about what kinds of reforms are both worthwhile to focus on at the state level and also possible at the state level. So that's where I would start, and that's what I think really the opportunity is at the state and local level. Some of which we see in some legislation I know we're going to talk about, and which has both been enacted and also is under consideration.
Just wanted to say one plug for federal law, and one big benefit of federal law is that you would have a universal precedent, right? So when federal court decides something, then it sort of carries much farther than if a state court decides something within their jurisdiction. That stuff can be persuasive, but it's not as far-reaching as what federal immunity reform would actually do. But that doesn't mean that states should just sit and wait, especially given that the Supreme Court and Congress have so far been not very willing to engage in this.
Well, let's go to maybe what is the actual situation in the states, and that can lay the groundwork for what reforms that could be made there. Anya, if you could give us a breakdown about our recent 50 Shades survey and some of the pluses and minuses out there.
Absolutely. So the first bucket, right, the baby 1983, the civil rights statutes, we have 8 states, and these 8 states explicitly authorize suits for violations of state and, in some cases, even federal constitutions. These 8 states are Colorado, New Mexico, New Jersey, California, Connecticut, Maine, Massachusetts, and Arkansas. So of these 8 states, only Colorado, New Mexico, and California prohibit the imposition of some sort of immunity that makes suits difficult. And of these 3, only one, New Mexico, does not limit the statute to a particular set of claims. For example, in Colorado, right, it's limited to law enforcement officers. That's why New Mexico gets the highest grade, an A-, and Colorado gets a C+ despite its strides. California gets a B-. There are also, by our count, 15 states where high courts allow claims directly under state constitutions the Bivens action analogs. There is definitely some discretion baked into this number. We didn't count some of the states like Texas and Mississippi, for example, that technically have an implied right of action, but it is very limited or was put into doubt by subsequent decisions.
Anya, sorry to interrupt, but don't some states say they only give an implied right of action, but for takings claims? Because the argument is that it's right
Indiana.
in the provision, the takings provision. Well, of course, you wouldn't have a remedy because it says it says you have just compensation, but it's really just limited to take. I think in my state of Minnesota, they've hinted that that's the law.
Indiana is similar. That's why we don't count, for example, Indiana in our in our buckets of states with implied rights of action. Iowa is an interesting state, right? It does allow suits directly under the Constitution. It does not adopt the federal version of qualified immunity. It does still adopt immunity, a due care qualified immunity standard, but it's not as difficult to overcome as it would be if it were a federal standard. So there's a lot of variation between the states there, but generally speaking, still, it's either the implied right of action is very limited, like your example with the takings clause, or you have very difficult immunity doctrines, immunity barriers to overcome. So we have 8 states in the first bucket of baby 1983 statutes, somewhere around 15 states implied right of action statutes, and then finally, you have these states, the rest of them that don't have either one or the other, and all you have there are, tort claims acts, and in those states, immunities are, very, very difficult to overcome. And that third bucket, generally speaking, in our study, is the lowest performing bucket, even though some of the states do have better tort claims acts than others.
So by far the best, it sounds from your summary, Anya, is New Mexico with its recent reforms. Patrick, could you give us just an overview of that and perhaps what it has that is superior to reforms in other states, including Colorado, and where people could turn to maybe how to write this kind of legislation?
Yeah, sure. So one thing that sets New Mexico apart, and we should say that New Mexico's legislation is newly adopted. They adopted the most broad sweeping civil rights statute in 2021. And I think what really sets it apart from states like Colorado, which have also moved in a good direction, is that the New Mexico legislation isn't limited to, and this is the most common limitation we're seeing now in legislation that's being proposed in various states. It's not limited to law enforcement officers, because just as a reminder for everyone, whether it's qualified immunity or anything else, these civil rights doctrines and constitutional issues are not issues that are limited to police. Yes, of course, police are very common actors in the space because police are the most common government official that people interact with, whether they're state police or federal police. But this issue is much broader than policing. And so one of the things that makes New Mexico special is that its legislation doesn't focus only on policing. And another thing that the New Mexico bill does is it focuses the liability on government employers instead of individual officials. And so under 1983, for instance, if you're going to bring a lawsuit, you're almost always outside of a Monell context, like Alex mentioned earlier, you're going to be suing an individual official. And there's been great work done, in fact, work done by Alex and his co-authors on this new paper. They had another paper called The Myth of Personal Liability that shows that the idea that although you're suing individual officers, the actual officer might be bankrupted or something is just not true. All of the evidence shows that no matter what, when you're suing an individual officer, their employer or some insurance contract is paying for any damages that might be awarded if you can get through the morass of different immunity doctrines. And so what we've done with a piece of model legislation that actually went on to kind of become, as modified, the New Mexico Act, is we say, well, let's just have the government employer be the primary liability source, because that way you know that there's always someone who can be liable, who can pay damages that are awarded against the officers, because our primary concern is that every right has a remedy. And so it's not so much about directing the actions of an individual officer, but It's about making sure that if your constitutional rights are violated, you can go to court, whether state or federal, and get a remedy for that violation, because that's what essentially a right allows, is that you have something that can't be violated by the government. If it has been violated, they need to make you whole. And so the New Mexico Act largely does that, with very few exceptions. Obviously, there's no immunity carved into that act. It's not limited to police. And that's sort of what makes it so special in our mind. And obviously, we're somewhat biased because it is based on the Institute for Justice's PECRA model legislation, Protecting Everyone's Constitutional Rights Act, which sets out kind of the things that I just highlighted here, which is just to ensure that if your rights are violated by a state actor, you can go to court and you can sue, and then someone will have to pay to make you whole. And that allows the incentive structure to place incentives on government hiring, firing, supervision, and so on and so forth. Because at the end of the day, the reason that a police officer or any sort of revenue officer or a code enforcer can come do things to you that violate your constitutional rights is some state or locality or federal government has given them that power over you, and therefore has implicated the Constitution.
Well, going further down the scale, Alex, if you could tell us about maybe some of the in-between cases and the pros and the cons that are out there. A couple to throw out there, but please feel free to add any others, are Colorado and North Carolina.
Sure, I'll talk about those too. And I'll also say, for folks who are interested in reading more about the point that Patrick made about the myth of personal liability, I commend anyone to look at the work of Joanna Schwartz, my co-author on this paper, but also author herself of many excellent papers on qualified immunity in general, but also this specific question. So Colorado's law, I do think it's in a positive direction, but as my colleagues here have said, it's more limited than New Mexico's. It provides a private right of action for violations of state constitutional law by Colorado law enforcement officers. And it specifically prohibits the use of qualified immunity and state statutory immunities as defenses to claims brought under this section. It provides for attorney's fees for prevailing plaintiffs, another important element of these laws. On the indemnification question, what it does is it says there will not be indemnification if the officers are convicted of a crime. That's one thing it says. And then it also says that if local governments decide that their employee was acted in bad faith, then the local government can require indemnification, contribution by the officer of up to $25,000 or 5% of the settlement or judgment, whichever is less. So it mostly will always provide for indemnification. Indeed, it says that if the officer can't contribute, right, if the officer cannot financially contribute to the settlement or judgment, then the employer will cover the difference. But it has built into it this idea that officers should, in the main, contribute to some limited amount of the settlements or judgment, which I take it was a judgment by the legislature that this might result in greater deterrence by officers in engaging in this kind of conduct. And I think this is a fair question on which reasonable people can disagree. Joanna, Jim, and I also have a model statute that's much more like IJ's, where in general we think that the weight of the settlement or judgment should fall on the employing entity, but we have a provision that provides for some limited contribution in certain circumstances because we can understand the argument for why you'd want that. So that's Colorado. It's progress, but certainly more can be done there. North Carolina is one of these states in which there's no statute, but there is an implied cause of action that courts have recognized under the state constitution. And it seems that it is one of the broader implied rights of actions. As Anya said, in almost all of the states where there are implied rights of actions under the Constitution, there are significant limitations on the kinds of actions you can bring. And North Carolina Supreme Court doesn't seem to have imposed those kinds of restrictions. Of course, it could in the future, but as you read the case law, it seems to have a general rule that If there's no statute that provides an adequate remedy, then the common law, the state common law, will provide it under the Constitution. So that's one distinguishing feature of North Carolina's implied rights of action. The other distinguishing feature is, at least so far, the court hasn't said that there's a qualified immunity as a defense in these kinds of actions, which, in our view, leaves it as an open question for now. So these are less, I think, transformative than the New Mexico legislation, but still examples of what states can do to create a more vigorous civil rights enforcement scheme.
And then there are states where things just aren't really that great at all. Anya, tell us about a few of those. I think there's probably more of those than there are the others.
Yes, indeed. And, as a former Soviet, I love talking about bad performers. So Delaware and Alabama, right, are good examples of what it takes to get an F in our study. In both of those states, you can't sue directly under the Constitution. In both of those states, you don't have any kind of analogs to 1983, any kind of a civil rights enforcement statute. And in both of those states, you have extremely limited Tort Claims Acts, right, where essentially the rule is that there is a blanket immunity, and then there are certain very limited exceptions to those immunities. Arkansas is another interesting example because you actually do have a civil rights statute there, but it doesn't really perform that well in our study. And the reason for it is that, first of all, you have pretty limited Tort Claims Act, right? The non-constitutional personal injury cause of action statute. And in addition to that, even though you do have a baby 1983 statute, it is inhibited by immunities, actually explicitly adopting a federal qualified immunity standard, plus there is a state immunity standard that's kind of on top of that, making it really, really difficult for plaintiffs to overcome that and take advantage of this great statute.
I have before we move on to what's going on right now in state legislators and courts, Alex, I have a follow-up to what Anya was just saying. We've been talking a bit about how if you file just a regular tort claim, but who you're suing happens to be a governmental actor, kind of the Blackstone model of vindicating maybe not your rights, but just being made whole. We've been talking about how they're often narrow and there are all these exceptions to bringing causes of action. Can we say something broad and general about them and how they're kind of like qualified immunity, but it's a little bit different? Or is it just it's 50 different ways, to protect the government from having to pay you?
Well, so in many states, it looks a lot like qualified immunity. In many states, it's an official good faith immunity. It's not quite qualified immunity, but it looks an awful lot like it. So that's point number one. The other point to recognize that in some states, it forces you actually to sue the entity, but then it creates all of these conditions on suing the entity, including a pretty narrow respondeat superior definition that in some circumstances really leaves injured people without a remedy. And one great example, or terrible example really, from New York is where the New York statute says if you're going to sue a correction officer for a common law tort, you sue the state instead, and sue the state in this very special court, the Court of Claims. But if the officer was acting outside the scope of their employment, then the state's not liable. And when the officer in this particular case was accused of beating an incarcerated person for no reason, the Court of Appeals says, well, that's obviously outside the scope of employment, so it's not covered by respondeat superior. So there are limitations that look an awful lot like qualified immunity. There are other limitations that are in some ways worse than what you see under federal law. So it's somewhat of a patchwork, but I think you can generalize and say still lots of barriers even at the state tort level.
And just one small point, I believe, isn't it true that usually or often the statute of limitations is very short. So I think here in Minnesota, you have to give notice and bring suit. Sometimes, I mean, it depends on how you read the statute, but as little as 6 months for some wrongs.
Yeah, there are notice of claims procedures in lots of these states. To be fair, though, my experience, at least litigating these claims in New York, is that you often can get permission to file a late notice of claim. So there are short statutes of limitations, but they can sometimes be overcome depending on what jurisdiction you're in.
Well, with all of this in mind, I'm sure the listeners are thinking, well, I hope something's being done about this. So that's true. Things are being done in various states, not all at once, but there is movement. So, Alex, you could start us off with what's going on in your home state and in other states nearby.
Sure. So I'll start with talking about what's going on in New York. There is legislation that's been introduced in the Senate and the Assembly, parallel legislation. For New Yorkers, if you want to know, it's S 1991 and A 4331. And it is really very broad legislation. It creates a cause of action for violations not just of the state constitution, but also of the federal constitution. It applies to all state and local officials, not just law enforcement officials. There's no qualified immunity, and also it specifically overrides state law official immunities like the good faith immunity we were just talking about, Anthony. It ensures that states or localities will indemnify employees, except in the rare circumstances where they're convicted of a crime. But even then, frankly, there's a fail-safe so that people are insured of getting recovery if they either get a settlement or a judgment. It also provides an independent cause of action against municipalities and states, waiving state sovereign immunity. And it has a broad attorney's fees provision that provides for attorney's fees if your lawsuit is the catalyst for the government changing course. Now, that's a pretty important change for those of us who also bring and are interested in forward-looking injunctive claims, because sometimes what happens is you bring a lawsuit and the government says, oh, you're right, we were doing this terrible thing, we're going to stop doing it now, and so now we can dismiss your lawsuit. Well, you put a lot of work into bringing that litigation, and attorney's fees are often an incentive for governments to not violate the law. But under federal law, if that happens, you don't get any attorney's fees. The government agrees that they were doing something unlawful. The lawsuit gets dismissed. Unless you get an order saying they were doing something unlawful, you're not going to get attorney's fees. So this provides for those attorney's fees in those circumstances. So that's New York. It's still under consideration. It's gaining momentum in both the New York State Senate and the Assembly every day, frankly. Vermont has a statute that was introduced in January of 2022. It creates a cause of action. Now, this is just against law enforcement officers for violations of the Vermont Constitution. This is S-254. Also, no common law immunities, also no statutory immunities. Has a fee-shifting provision that's not as broad as New York's. It also has an indemnification provision that is very similar to Colorado's. There's really tiny marginal differences there. So that's another example. I would say Vermont's is modeled pretty heavily on Colorado's. And then the last is New Jersey, which has had some stops and starts. There was some legislation introduced in 2021 which didn't go anywhere, and now there was legislation again introduced in January of 2022, which is a different, as I read it, a different approach to the problem. It's not so much that it's creating a new cause of action, but it's specifically saying there will not be qualified immunity or similar good faith immunities when law enforcement officers are sued in New Jersey for these kinds of violations. So it's a slightly different take on a similar problem. So that's where we are sort of near me.
Well, great. Well, Patrick has the unenviable task of taking the rest of the country. We don't need 47 states today, Patrick, but any you'd like to highlight?
Yeah, definitely. I have an encyclopedic knowledge of all the other states. I just don't want to share that with everyone right now. So I'll just say instead, there are some other states where there is some movement. There has been a statute that has been introduced in Washington state, but it sort of suffers from some of the same drawbacks that we see in Vermont and Colorado because it's focused exclusively on police officers. And I do have a little bit of concern, having read the language of the statute, that it could run afoul of some of these concerns that Alex has highlighted about the respondeat superior standards, because I think a lot of people imagine that when you say you can sue the employer in the same way you could under tort law, they're not thinking like, oh, well, if the person happens to violate the law or the Constitution, that will become an excuse for not allowing liability. And this, in a cruel irony, is sort of the same exact argument that was made by the government in Monroe versus Pape, the case that Alex mentioned at the beginning, which sort of gave us Section 1983 as it operates today. The government officials come in and say, well, what we did was so bad, you can't hold us or our employer liable because it was outside the scope of our employment. And the Supreme Court in Monroe said no dice on that one. But state courts are very used to applying this sort of common law respondeat superior in, for example, situations where they're employers and employees. And if an employee violates the law, typically the employer is not liable. And so statutes like the Washington statute could run into litigation issues with that over the next few years if they pass. Obviously, there are other alternatives that can be taking place. Like any state can, or any city or municipality can do something like New York City did, and allow, within the bounds of the city or city officers for there to be similar liability. We expect there will be movement in the state of New Hampshire as well, and we were involved in some legislative attempts in New Hampshire in the last year or so. And a lot of other legislators are kind of thinking about what they can do, when they can do it, what's the best strategic time to do it. And I don't know. I still think that the focus on policing is difficult because A, it limits the constitutional reach, but B, it also makes it into a more seemingly partisan issue because then it becomes a pro-police or anti-police position. And that's not what this issue has ever been until the last few years, unfortunately.
Well, as these various states are trying to better their laws and legislators are looking closely at proposed legislation, what they most should be thinking about is how to get an A under the 50 Shades of report. So, Anya, how do they do that?
So since we are calling here for legislators to do something, I'm not going to talk about the high courts allowing suits directly under their constitutions. We're going to put that to one side. But if you are a legislator and you want to make a difference in your state and open an alternative courthouse door under state law, then pass a civil rights statute, right? And make sure that that statute is not limited to particular claims or particular government employers. And also make sure that that statute is not limited to, by immunities. Easier said than done. Any step in the right direction is a good step. But if you do want an A, that's what you should do.
Well, I think we've had a great primer here on the issue, what's wrong, what could be done better, and what's going on. But anything else any of you want to add to what the listeners should know about this?
Yes. I want you guys to tune in to our final episode of Season 2 of Bound by Oath, where we will explore this very topic in depth. And Alex is going to help us do that. We rely on his interviews pretty heavily in that episode. So please tune in for the final episode and listen to the entire season. It's riveting. And one more thing, too. In addition to Alex, Joanna, and Jim's paper that Alex talked about, please read their amazing op-ed in the USA Today that was published over the weekend to get a better understanding of what's happening and what's going on and what should be done.
And Alex?
Well, so I would only say, remember there are lots of different ways for cities and states to think about their role in ensuring that all of our civil rights are protected. And so we've been talking about one very important way, which is creating rights of action for people to vindicate their rights. But the other thing to think about is how do cities and states defend these claims? how do they make decisions about what kinds of arguments they're going to make when they're going to invoke qualified immunity or other kinds of immunities, and how they think about their own role in a civil rights ecosystem. Because we're living in a world in which, in many jurisdictions, so-called progressive prosecutors are promising to think about the criminal legal system in a different way. And I think we should expect the same of the people who are defending police officers in court or corrections officers in court or other public employees in court every day.
Well said.
Yeah, and I'll just, if I can just add to, if I get my little plug here, what I would say is we get, a lot of people reach out to us and ask individually, I'm a person, I'm just one person, what can I do? And at this point, what you can do is, you can join the IJ initiative, Americans Against Qualified Immunity, but you can also call your legislators, whether it's state, local, or federal, and say, hey, do something to fix this. And if they say, yeah, okay, what? Well, point them to Alex's paper where they have model legislation, or point them to the IJ website where we have PECRA model legislation. And in our case, we have an entire legislative department who will work with state or local legislators to tailor PECRA in a way that will best help accomplish whatever goals are in most need of being accomplished in your state or locality. So there are resources for you. And the longer people can keep up the drumbeat of we want our constitutional rights to be enforceable, the more likely that they will be enforceable in the next year or 10.
Well, and those various papers that have been mentioned, we're going to put links up to them in our show notes so you can see them in your podcast app or also on the Short Circuit webpage for this episode. So if you're looking around for them, please find them there. And otherwise, thank you all for coming on. This has been a fascinating subject, something I really don't know that much about, even though I do this Short Circuit podcast. And so I think our listeners are probably saying the same thing. So thanks, all of you.
Thank you. It's great to be with you.
Thanks.
And for everyone else, please look forward to our next episode where we'll go back to the federal courts of appeals. But in the meantime, I want all of you to get engaged.